Good morning. Are you Kenneth Bartol?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file in each of the cases.
Before this case can even move forward, the judge tackles a critical question. Is the defendant mentally competent to stand trial? In criminal court, that's a huge deal. If someone can't understand the proceedings or assist in their defense, the entire process can grind to a halt. Here, the expert evaluation clears that hurdle and the case moves ahead.
Mr. Barthol was evaluated by Dr. Kahan for competency to stand trial, and we received an evaluation and report back on November 3rd of 2025. The finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor. No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So, Mr. Barthol, in cause number 25, DCCR 1207, you're charged with the third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Mm-hmm.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR, that's a state jail. Are we going on count one only in the state jail case?
So is that
1752?
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then lastly, we have cause number 25 DCCR 0878. And in that case, you're charged with a third-degree felony offense of obstruction or retaliation from May 24th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1.
This is one of those courtroom moments that happens fast but carries enormous consequences. With guilty pleas entered across all three cases, the focus shifts from proving guilt to determining punishment. Notice how the judge carefully confirms the pleas are voluntary and that the defendant understands exactly what he's giving up, including the right to appeal.
1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted. Is there any, again, there's no other evidence about competency. All right, Mr. Barthol, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 25, DCCR 1752, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1207, Also find that you enter your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 25, DCCR 0878, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to go back real quick because I think I failed to mention, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Okay. These cases will run concurrently, which means together at the same time. I will sign dismissals as part of this agreement in cause numbers 25 DCCR 1206 and 25 DCCR 1208. I'm handing you in each of your cases the trial court certifications. That shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Okay, all right, Mr. Freeman, in cause number 24, DC, hold on, so let me get to it. '24 DCCR 0348, you're charged with a first-degree felony offense of murder. That's from March 27th of.
Now the stakes skyrocket. The defendant is rejecting a plea offer in a murder case, a decision that could dramatically change his future. The judge isn't trying to persuade him one way or the other. She's making sure he understands the risk. If convicted at trial, the sentence could potentially be stacked on top of an existing punishment, turning decades behind bars into even more time.
2022. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Well,
And then in cause number 21 38728, you're charged with deadly conduct, discharging a firearm at individuals from October 22nd of 2021. And that's a third-degree felony, which means the punishment range, if you're found guilty, is between 2 years and up to 10 years in prison. Do you understand?
yes, well.
I have plea bargain rejections in each of those cases that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. In the murder case for a 60-year sentence that would run concurrently with the aggravated robbery sentence that you've already received. You have every right to reject that, go to trial, have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, well.
Do you want to reject that offer and have your case set for trial?
Yes, well.
Judge, I would ask the court to admonish him about consecutive sentences.
So is because of that prior conviction, I guess I have the legal question of they can be run consecutive, even though weren't they out of the same?
No, ma'am.
They were not.
That's
They were
not-
different offenses, and that was a previous offense. The date on the aggravated robbery was prior to the murder.
See, I got the indictment right here, Judge.
I mean, I guess the conviction's prior. But does it require the offense?
Not for
date?
consent, I mean, just different offense dates as well.
Is that your understanding as well?
It's not a, yeah.
So I do want to make sure you
not a
understand.
Criminal episode.
That's right.
Okay. that because the aggravated robbery and the murder were different criminal episodes, different dates, different allegations, that if you're found guilty in the murder case by a jury, and you're sentenced to some number of years, the state can then and will, I'm sure, ask that I run any sentence that you receive consecutively, which means stacked on top of each other instead of concurrently like they're offering now. It would be up to me after I hear all of the evidence. I want to make sure you understand that that is also a consequence that you could be facing if you're found guilty by a jury. And do you understand that as well?
Yes, ma'am.
And do you still want to reject any offer and go forward with the trial?
Yes, ma'am.
Okay, then we'll get your case set. And I guess the deadly conduct, which is it was what was part of that. I don't see a rejection. Was it just either to run concurrent or to be dismissed?
It would be
Okay.
run concurrent or dismissed.
Okay.
The focus is on the murder.
All right, so I will set the murder for trial. I do want to make sure, Mr. Freeman, that you understand that after today, I will not accept any plea agreements. The cases obviously are very old, and part of that is because we handled the other ones and there's been appeal, and so some time has passed. And so your case is going to get bumped up pretty quickly for the top of the trial list. And so if there's any other negotiations, I need to know about it well before the trial or the pretrial date. But unless there's new information that comes to light for your attorney or the state's attorney, I will not accept any plea agreements. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Judge.
Yes, sir. Thank you. Good morning. Are you Eric Segrist?
Yes, ma'am.
And Mr. Segrist is charged in cause number 25, DCCR 1836 with burglary of a habitation. Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at $50,000. Mr. Lewis, you may proceed. Mr. Seeger, as best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Go ahead, Mr. Lewis.
Mr. Seacrest, will you state your full name for the record?
Eric Martin Seegers Jr.
Okay, at the time that you were arrested, were you employed at that time?
I actually I had a job interview for Walmart the next day and I missed it.
But you, at that time, you weren't working?
No, sir.
Okay.
No, sir.
Up until the time that you were arrested, were you able to have any money saved or anything like that that you could use to forge your bond?
No, sir. My sister was planning on helping me out.
Okay, so any help would come from your family?
My family, yes, sir.
Okay, now the employment opportunity that you did speak of, is that still available to you?
Yeah, as soon as I go home. Like she actually asked about me yesterday morning.
Okay.
And I have a neighbor in my neighborhood.
Mhm.
And she has like a bunch of overgrown trees, and she was asking my sister if I could come over there and clear out all the stuff, and she was going to pay me to help bond out.
And if you're able to make bond, where would you be living?
At 6161 House Street in Groves, Texas.
Okay, now is that the same residence as the complainant in this case?
No. So that's my sister's house.
Okay, so you will be able to handle any type of bond conditions, for example, like no contact with the victim, things of that nature.
Absolutely, and the job is walking distance from my house. Like it'll take me 20 minutes to walk there, my house. And I just bought a brand new bicycle, so I could ride my bike straight to Walmart to go to work.
Okay, now as far as the bond amount, it's currently set at 50,000. About how much do you think your family could afford, reasonably afford to try to help bond you out?
Well, I'd say because I have another bond that's 10,000, and so probably around that area, so she can get a better deal with the bondsman, like around 10,000.
So you're asking for a bond to set at 10,000 on this case, but ultimately you would have a bond obligation of approximately $20,000.
Yes, sir.
Pass
What's
it
the other bond for?
It's for an assault case, I believe, Judge.
I missed the misdemeanor.
It's a
assault.
misdemeanor assault case.
Any questions?
No questions, Mr. Judge.
Any other witnesses?
Oh, no, Judge.
All right, Mr. Smith, what is the state's position?
Judge, this was a case where he broke into this house, sliced his arm very badly on the window, trying to break through the window. assaulted the victim in the case, stole her phone and ran away after the police had been called. They were able to find him because they used to track my iPhone. It's family violence. They were living together at the time. We have had contact with her. She came in and talked to me last week, or before last, on this. So we would be opposed to a bond eviction.
And just for the record, I'm taking judicial notice of the court's file. It does include the probable cause affidavit, and so I have reviewed that as well. Anything else, Mr. Lewis?
Well, Judge, this is the one that we, of course, reset from recently when the state was looking to hear from the complainant in this matter. And I think, like Mr. Smith said, they did have a chance to talk to her. And even from my understanding from that conversation, what we're dealing with is a situation where it's still kind of shaky as far as factually of what went on between him and her that evening. It is something that he definitely wants to pursue. I'm not just going to say a trial, but pursue this matter further as far as trying to get it resolved. He does have plans to hire his own attorney, who is Mr. Parker. He's gone now, but that's initially who was the family's going to try to help hire for him. So they're looking to bond him out and hire his own attorney as they proceed with this matter. We're just asking for him to have that opportunity. That way he can get back to work and help pay for that on his own and not be situated with any burden or obligation on his family moving forward.
Okay, at this time, taking into consideration the factors in Art 17.15, I am going to find that it is not in the best interest to grant the motion to reduce the bond. I'm going to deny that. The underlying facts, the testimony today. And so what we'll do is get it set as quickly as possible. If the family hires Mr. Parker, great. If not, then Mr. Lewis obviously will remain as your attorney and move forward with going through discovery, and we'll get it set for an announcement and move forward as however you guys plan to at that time.